So good morning, everyone. It's a pleasure to have you here with us early in the morning of the second day of the CPDP. We hope that you didn't have a hard time finding the room, but many thanks for joining us. So the room resembles like a university amphitheater, so we were joking earlier that it would be nice to say you can take out a piece of paper and write what you know about data spaces. But on the contrary, we're here to discuss today with a very well set of distinguished speakers about securing personal data in common EU data spaces. What does this mean? What are common data spaces? How they relate to emerging legal instruments already in place or very close to being in place. And again, many thanks for joining us. So, my name is Prokopios Drogaris. I am within ENISA, the European Union Agency for Cybersecurity, and I work there as a cybersecurity expert and deputy data protection officer. So, you might wonder what is the relationship or what does ENISA have to do with securing personal data and common EU data spaces. I am sure you have all noticed that cybersecurity is becoming a horizontal element in a lot of latest union policy and law. And Data Governance Act is no different. Actually, ENISA has a role to play as a member of the European Data Innovation Board in order to provide advice and support with regard to cybersecurity aspects of common EU data spaces. And on top of that, ENISA, under its mandate, also is meant to support member states to implement cybersecurity aspects of union policy and law in privacy and data protection. How did we reach the point of talking about common EU data spaces? I will attempt not to go in a definition because the speakers after me will briefly talk about that. Given the different expertise and the different institutions they represent. However, I should note that you might hear today a lot of personal opinions, so whatever they might say or they might be intrigued to say or reveal, most likely will represent their personal opinions and reflections and not necessarily the institution they represent. So, when we talk about data spaces, data sharing comes into mind. And data sharing seems like something that we are rather well acquainted to, but have not really understood how did we reach this point. We have experienced over the last couple of years a very big increase in the amount of data that are being generated and processed. And there seems to be a trend of taking the data out of devices and organizations in order to make the most out of them. On top of that, we have actually reached the point where we are sharing data among different parties to create new value for the data, for ourselves as an organization, and in some cases also for others. So data sharing can be considered as disclosing data to third parties outside the organization in order to achieve a specific purpose. This purpose can be either very well linked within the organization itself, so you can think of a cloud infrastructure where we're sharing the data in order to facilitate the processing, both in terms of capacities, but even in terms of security. So instead of having the infrastructure in-house and being responsible for maintaining it, transitioning to the cloud, in theory, or a number of years ago, I'm not saying it's not the case now, but I'm just attempting a dive back in the future, in the past. The fact that the cloud infrastructure was managed by someone else meant that we didn't really have to care about patching all the servers with the latest update because this was done centrally. Further to that, we might be sharing data with third parties, as they might be a recipient, in order to create added value for this recipient or in order to facilitate their processing operation. So all in all, the notion of sharing or the actual sharing has been taking place for quite some years now for different reasons. I named just a few, but I'm sure you can also think of such examples from your experience. So we reached to a point now where this whole notion of creating value from data that already exists is something that was highlighted first by the Data Act and then by the Data Governance Act. The aim of this panel, as the title very well implies, is to discuss common EU data spaces and how to protect personal data, including also aspects with regards to the security. The members of this panel that you see next to me, and I will introduce to you shortly, were invited based on the composition of the European Data Innovation Board. So we're very happy to have together with us the chair of the European Data Innovation Board, a representative from the European Commission who chairs the board, also a representative from the EDPB and the EDPS, and also, given the focus of the Innovation Board with regards to technical standards, a representative also that has a very long experience both in data protection and also technical standards. So without any further ado, I would like to introduce to you the first speaker on my left, Mr. Malte Beyer-Katzenberger, who is a lawyer by training. Since 2011, he works for the European Commission DG Connect as a policy developer and team leader on data-driven innovation. Most recently, he has been involved in the formulation of the 2020 European Data Strategy, and he has developed and negotiated the Data Governance Act and the Data Act. Malte, thank you very much for joining us, and the floor is yours.
Well, thank you, Prokopios, and thank you for all. Despite the sunshine, you made it into a dark room at this early hour. I think my mission this morning is probably twofold, and the first and most important mission is to demystify the concept of data spaces. I think a lot of people out there that we listen to have the idea that there is a huge mega infrastructure, repository, interconnection being built, including through legislation by the Commission. And I would say this is wrong. This is just not the right way to look at it. It's also true, we had yesterday a discussion, I think, on one of the panels on the nail and the hammer and the ambush kind of situation. So we tend maybe to also expect to see something because our kind of eyes are trained to look for legal rules, legal obligations. But what we're seeing with data spaces is first and foremost something that grows out voluntarily, grows out of industry, grows out of a business interest to stabilize digital collaborations. So you may want to consult our staff working document from 2024. It's SWD 2024 number 21, which we published in February. However, I think what you will find there, and I'm speaking under the control of a colleague of mine from DG Connect, is a bit of a blurry kind of attempt to definition. I think if you want to properly understand what is going on in the world of Gaia X and also in terms of what the Commission will support to happen in terms of data spaces development, it's first and foremost to look at it as a stabilized digital ecosystem. Stabilized ecosystem means that it's an ecosystem where companies and maybe also other entities, research organizations, the public sector are agreeing to work together contractually on a set of common technical standards, which are then supported also by a legal contractual architecture that says if you want to exchange data in this data space, we will use this technology, this protocol, and these security means to make sure that everyone feels comfortable and that we can trust each other, and you are abiding by it contractually. So there is indeed some sort of onboarding and offboarding process, a validation to come into the data space and say, are you ready to implement these technical features, notably a connector software that says, well, we will exchange in this space data on the basis of this data space connector. And are you ready to do this? And will you also leave the space and stop collaborating if you were found violent? This brings, first and foremost, a trust in an open, voluntary digital ecosystem. What is the business need out of which this grew? The business need is first and foremost industrial supply chains. So yesterday we also long discussions, is there something like non-personal data? Yes, there is. In industrial supply chains, a lot of quality data are being exchanged because along supply chains, manufacturers have to be sure that the end product conforms with certain requirements, product safety requirements, and in order to know that, you have to have a lot of information from your suppliers. So the nucleus of the whole concept of a data space, you find it in what is now called Gaia-X, and especially in the German manufacturing industry. I think the most evolved data space has the brand name Catena-X, which is about automotive supply chains, where there is now a framework being put in place according to which the players exchange data. So that's the second, I think, important thing, to also think there are industrial problems around trust in non-personal data. Why is this? Because you have a rather, how can I say it, focused rules on protecting industrial IP. You have a whole IP framework, including patents, and then you have the trade secrets rules. If you know a little bit about trade secrets protection law, it's basically conceptualized as a self-defense regime. There's prohibited actions, and you need to take someone to court when you feel this party has violated your trade secrets. So it's ultimately a very imperfect way, because very often it will be very hard to prove that something has gotten wrong. That is the underlying trust problem, that you have a rather imperfectly regulated protection of non-personal data. And so what we are now seeing is that under this kind of big umbrella of Gaia-X, which has developed a reference architecture, which is just an architecture, it's a schema, a technical schema supported by legal elements to enforce the schema, is being applied use case by use case on a voluntary basis by companies. That's the heart of the origin of the concept, and that's also how it's mostly applied. Now you have two other situations where this is not the case, and that's where people say, well, but there's something like called the European Health Data Space, and I know there's a regulation on this. And that's true, the European Parliament has also voted it, so the final trilogue text is public on the gateway of the European Parliament, but the health data space is really the outlier. There's no intention, to my knowledge, that we will have a comprehensive regulation for any other data space in the same completeness. There may be rules on certain facets of things that may happen within a data space. There may be rules on certain obligations to share data in the automotive aftermarket for repair and services. There is now the Data Act, Chapter 2, that says if you have a connected machinery, you can exchange the data. You have a right to receive a copy of the data. But whether you do that within a data space or elsewhere, is completely up to the company that owns the device and has then a right to receive the data. So there is, at best, really targeted kind of rules. What we also have is, and I think Mario will also expand a bit on this, we have regulation on data intermediation services. That's in the Data Governance Act, Chapter 3, where we defined certain functions that will probably most be relevant within data spaces. Because to connect this open ecosystem, you need some connecting elements. You need someone who holds the whole thing together, to runs or manages the day-to-day business, onboarding, offboarding with Spoke. It's about discovery services, which data can I actually find and who has it, who's going to trade with me or not, where are the applications, can I maybe also pool certain data, is there a trusted kind of instance where I can put my data together with another party without that we're kind of ripping each other off from a competition. So you have certain data intermediation service in the thing. And then you have a third category, which you also find in this rather blurry definition in the staff working document, where the public sector makes a strong effort to push out certain resources it has under its disposal. One example are language resources for developing multilingual digital services, not least generative AI, also in the lesser spoken languages. You have cancer imaging database federation attempts, and also genome databases. And for all these players, especially now with these hot kind of cases, you have to apply the GDPR. I mean, there is no magic to say, well, in a data space, the rules of GDPR are no longer applicable. They are. It's just a stabilized collaboration of companies in a kind of schema where you say, okay, we'll use the same sort of tools, protocols, and standards. But whether someone's a data controller, a data processor, what's the legal basis for processing, all that has to be found in agreements, consent, legitimate interest, all the tools that we know. The health data space is the outlier because it gives indeed a secondary right under certain cases for researchers and innovators for medical health, but it's really the exceptional situation. I want to get these measures across. Which leaves me maybe with my second big block that I want to get across. It's now the question, and that's really also, if you wonder how does the Commission sometimes reason, at which level actually do they reason? And this is a very conceptual level. The question is now, if we have these data spaces, what about individuals / consumers / citizens / data subjects? What is their kind of role? And obviously they have all the rights and obligations, well, obligations less, but rights under the GDPR. But as maybe some of you know, I'm quite exposed to the My Data thinking, which is not only My Data Global, which has a parallel session, unfortunately, right now in another room of this conference, but also Anne Kavoukian, probably no stranger in this grouping, who brought to me, like in 2013, a little paper that was saying, in the future, the organization-centric thinking of storing, processing of personal data should actually end. The bright future that she predicted together with Drummond Reed in 2013 is that it will all revolve around personal data clouds. It means every one of us has a little secure cloud space, and from there on, the data will be consumed, processed on the need basis. But we finish this infinite just on case storing of personal data in organizations which is really still the architectural design of a kind of IT data economy today. Is this ever going to happen? We don't know, but I'm saying it also in this building, which is the building of the Flemish government, where the Digital Agency of Flanders has made a lot of effort to roll out what is called the Solid Protocol. Tim Berners-Lee has made one attempt to roll out basically personal data pods, as they call it, in the Solid Protocol. And the Flemish government has said we will experiment with this in certain use cases, and not only government-facing, but also private sector-facing use cases. And the company that has commercialized, or that brings this to the residents of Flanders, is called Atumi. It's a government-owned company, but might spin out at some point. So we see some baby steps to make this happen, but why has it not happened? We can have many, maybe in the discussion also many questions around this. But the idea is basically that my vision, my personal vision, would be that a citizen / data subject / consumer / individual travels across data spaces with his own space. So he doesn't have to log on to yet another account and find my this account and my that account, forgot the password, get a password manager, forgot the password manager, and having all these kind of stupid problems, the small print problems. And then, my last word, also federated machine learning can happen, because then you can actually deploy the algorithm to the individual spaces, and you can really do privacy at a very high level design. This is maybe my vision. There's a lot of pitfalls of this. I'm completely aware, but this is the thing I want to throw out to discussion this morning. And that is also why we have regulated this in the DGA Chapter 3. And there is an obligation, I mean, maybe you find it in Article 12, I think letter M or L, where actually the provider of such a personal data intermediation has to act in the best interest of the individual. Best interest is a quote from the text, which is a safeguard. It's another word for saying fiduciary duty if you are from a US background. But we have put this there to give at least these players a chance to have a legal framework where they can say, look, I'm trustworthy by legal design because I register my service as a data intermediation service, and I'm under all these conditions of Article 12 Data Governance Act. So this is all how it fits together. But now I'm handing over to you or to the next speaker.
Many thanks, Malte. Very interesting insights, and I really enjoyed the connection you made with the personal data cloud. We could perhaps have a discussion afterwards of whether this, if we jump into another legal instrument, the digital identity wallet could be seen as something like that, but let's leave it for later. I would now like to give the floor to Anna Litra from the European Data Innovation Board, where she serves as a legal officer and deputy data protection officer. She joined EDPB in May 2020, and she holds an LLM in law and technology from Tilburg University, and she's also a qualified lawyer in Greece. Before joining the EDPB, she worked in the field of data protection and cybersecurity at an international law firm and at a French consulting company, and she specialized in compliance tools under the GDPR, including binding corporate rules, code of conduct, certification schemes, and accreditation requirements for monitoring and certification bodies. Anna, the floor is yours.
Good morning, everyone, and thank you, Prokopy, for this thorough introduction and for organizing this panel. But also, yeah, thanks to you for joining so early in the morning. So yeah, my name is Anna Litra, and for those that don't know what the European Data Protection Board does, is a European institution, is an independent body consisting of the EU and European Economic Area Data Protection Supervisory Authorities and the European Data Protection Supervisor. We have a representative here, Mario, today. So it's not an appeal, not a regulatory body, and its mission is to ensure consistent application of the GDPR throughout the European Union. And how do we do that? By issuing guidelines, best practices, consistency opinions, binding decisions, and other documents. So with regards to the regulations establishing data spaces, I would like first to highlight that from our side, our current strategy until 2027 has in the core these new regulations of data strategy and digital service package. So we'll keep on monitoring future evolutions and following this closely. And also would like to thank the Commission who consulted us on some of these new regulations establishing EU data spaces, such as the DGA, Data Act, European Health Data Space, and we are glad that they took some of our recommendations into account. So to begin with, there are several data spaces, such as the European Health Data Space, Agricultural Data Space, but I will not go through all of them because Mario will cover some more. So I will mainly focus on the DGA, but on the Data Governance Act, but some of the comments I will have, some of the data protection considerations will be applicable horizontally on all the data spaces. So it is important also to keep in mind regarding, like, in order to determine the data protection challenges, like the specificities of each data space, such as the purposes or the nature of data processed. So as I would like to elaborate further a bit more on what Prokopis mentioned on the role of the European Data Innovation Board, where EDP and EDPS have representatives. Its role is very important because it will assist the European Commission drafting guidelines on many important matters applicable to EU data spaces, such as cross-sectoral standards, requirements to counter barriers to the market entry, adequate protection for the lawful transfer outside the EU, and cybersecurity requirements in accordance with the Union law. So regarding some more relevant data protection considerations, and as also Malte said, and also Prokopis, when we have personal data processed, because they can be both personal and non-personal data, GDPR is fully applicable. So, for example, even if there are mechanisms used to process personal data to generate, for example, anonymized data sets, this still constitutes processing of personal data and thus is subject to the GDPR. So we'll start with some more concrete considerations, such as these of the legal basis. For instance, the DGA does not establish a legal basis for the processing of personal data, which means that in order to legitimize this process and make it lawful, one of the legal grounds mentioned in Article 6 of the GDPR shall be chosen by the controller. Very closely to the legal basis consideration is the purpose limitation principle. So the purpose has to be very specific, legitimate, and explicit. So like a general purpose such as social benefit is not enough to comply with this principle of purpose limitation. As we heard already from Malte and Prokopis, there will be a lot of reuse of data and sharing of data, so further processing of data, which means that the purpose for which the data were initially collected shall be compatible with the further intended purpose of processing. This is an obligation of the controller to ensure that the data are not processed in an incompatible way with the purpose that they were initially collected. In order to do this, the controller shall take several factors into account, among others, any link between the initial purpose for which the personal data were collected and like the further intended purpose, the context where the personal data are collected, like such as the relationship between the data subject and the controller, the sensitivity of data, if their sensitive data are processed, for instance, in the European health data space, maybe this assessment has to be stricter. The possible consequences on the data subject and any technical, any appropriate safeguards that exist. So yeah, I think that this is very important because the use of data is happening in almost all the scenarios, so this is something to be kept in mind. But also in general, all the principles of the GDPR, such as transparency, data minimization, shall be all taken duly into account and be complied with when personal data are processed in the data spaces. So this brings me to my next point, which is the qualification of the different actors, partially mentioned by Malte. So in the DGA itself, it's not very clear who is qualified as a controller or as a processor, or in which scenarios there are several controllers. Like there are several actors involved, such as data users, data holder, data intermediaries, and this qualification is very important to establish it because this will affect also the obligations that each of the actors shall comply with according to the GDPR, and also it's important in terms of liability. So furthermore, and I want to highlight again how important this qualification is, because it has an effect on the data subject's rights, because given all these many actors involved in the different life cycle of the processing, the data spaces, it is important that the data subject is aware where they can address their data subject's requests, such as the right of access, right to object to the processing, and all the rest provided by the GDPR. So it's very important to ensure transparency and to make sure that the entity that is the controller is compliant with the information obligations, and this will bring also trust to the data subject towards the processing in these new data spaces, especially when there is a use of personal data. So this ecosystem that involves different actors, it's also important to make sure that part of the governance arrangements of the data spaces are the data processing agreements, and that all the elements provided in Article 28 of the GDPR are in there, and each of the actors knows what shall be done with the data. I'm not sure I have more time, but last but not least, I would like to highlight two very important principles as well of the GDPR, which are very relevant in this context and to be kept in mind from scratch. The data protection by design and by default. So the controllers must ensure that by design they implement technical and organizational measures, while by default they have to really only process data necessary for the purpose at hand, and thus also we go back that the purpose has to be very specific, and so on and so forth. So yeah, that would be all from my side. Thank you.
Many thanks, Anna. You highlighted a completely different side of the same coin compared to Malte, and this is natural because as soon as the term personal data kicks in, all the GDPR obligations, requirements need to be addressed and are of course in place. Perhaps it's another element that we can discuss later on, but for now I would like to give the floor to Mario Guglielmetti, who is a legal officer at the EDPS since 2014. He has worked prior to that as a legal officer at European Commission DG Justice and Garante, the Italian Data Protection Authority. He also holds an LLM from the College of Europe in Bruges and a PhD in Constitutional and Administrative Law from the University of Trento. Mario, the floor is yours. We can put on the presentation, and the clicker is in front of you.
Each other. So it would not do justice to the audience to have this dichotomy between business and human rights, whatever good and bad. they have to coexist. So basically, Malte mentioned standards and business needs, but there are also, of course, other aspects to be taken into account. So I don't know if I managed to switch sorry for. Oh, maybe we can go to the next slides, otherwise I will talk without. Okay, so the case I would like to do is the following. So business needs and business models. And I try to make it concrete, my reasoning, my speech to you now, because in these 7-8 minutes, because I would really like to show you that the business needs cannot be let alone. This is an example of Cape Town. It's the optimization of a physical space in order to drive profits out of it. So basically, you can see that there is a huge barriers between the kind of, let's call it slum town and the villas, which are the only one who have access to the lake. It's a big lake, quite almost a sea. So you see here that the optimization of profit makes this kind of urban configuration. If business is left alone, also the digital configuration and the digital space, and we will look at it, will look like something like that, but it will be less visible. Instead of having physical barriers and walls, you will have digital barriers and walls. And basically, I make the example later on the financial data space. So you can find this data. There's an urban project which really shows, displays all these issues. A famous issue now, I just visited with the family in Lisbon. Lisbon, the same economic situation of maximization of profit has led to urban exclusion of families from the center of Lisbon, from the town of Lisbon, because the cost of houses and rents went very high because, of course, there was this incentive and market was left free to provide the houses to the one who could afford them to the highest price. And also Brussels, in a way, is also an example of urban segregation between communities. You see from some neighbors and other neighbors and the disparities which we have. So now if we go to the data space, of course, the definition has been provided, and basically it's not a physical space, it's more a logical space. It's also a space made of rules. These rules often are standards, and here, speaking about standards, indeed there is a need to point out that standards are private, made by industry, basically, and they are proprietary, they are not public. So in terms of constitutional thinking, if we rely too much on standards, we provide political guidance in the standards or directions in a way, or things which should be in tertiary legislation or secondary legislation, this is problematic. This is also an issue that we have with the AI Act. So with the Artificial Intelligence Act, rules on artificial intelligence, we have the same issue of standards and business needs that have to be integrated with the societal and human rights consideration. And then here I made a table which is a bit more technical. So you see, please check, because sometimes data users is used as a recipient, is a bit different, but you have the Data Act, the Data Governance Act, FIDA, and the European Health Data Space. It's about personal data. Of course, health data space is personal data, most of the cases. Financial information data access, this is also data space with the personal data. Yeah, absolutely personal data. Also to demystify these things that it's about industrial data, really would all this work have been needed if it was just about non-personal industrial data? No, I think there is an important element of personal data, and sometimes it's also mandatory data sharing rather than voluntary. So when it is mandatory data sharing, is the societal and the political discussion about the for what, about the end, or the aim of the data space is very important. We mentioned data intermediaries, and in this case also, it's very important to have, for example, in the register, I would say, information about the processing activities by the data intermediaries. Is it required, legally required? Maybe not, we can check, but for sure, if you want to have trust, if we have this EU label on data intermediaries, we have to really provide confidence to the public about what the data intermediaries are doing. And here, an important element to be taken into account, that this is not the whole universe of data spaces. I think it's still, especially from Data Act, DGA, in a way is a targeted intervention. I explain myself what I mean. That data sharing takes place already now and took place also regardless of the Data Act, between the manufacturers, between, for example, Google Fitbit and these partner companies and so on. What is the intervention about is that basically the manufacturers will also have to share data according to the scheme which has been envisaged, foreseen under Data Act or Data Governance Act. And also this data space, I had a slide in mind, then I didn't make it, is limited to the data universe. Consider the use of data scraping for generative AI. So this is still a little part, a little world, a little galaxy of the universe. If you see the universe of data sharing taking place now, and you compare to that altruism, altruism had to start in a way, maybe this is just one. And the mechanism envisaged for the mandatory data sharing under these acts is still, I think, limited in a way. Then maybe I can go, this is something we worked on quite a lot, also the DPS, opinion on consumer credit, and then now on FIDA. And here you see it's very evident what you put as data taxonomy or typologies of data which can or cannot be shared shifts completely the cursor of equality, of inequality consequences, impacts at societal level. Because, for instance, if you include, let's say, the medical bills, this was recently excluded in US because people with the medical bills inserted in the data space for credit scoring were excluded then, as a matter of fact, from loans. You see that it is not a theoretical question, it's a very political question, and you decide politically whether you want to move the cursor towards the profit maximization or towards a more integrated, a more inclusive society. And now the discussion, there is a strong discussion also at the Council on the granularity, because also the head of the chief data scientists for insurances, they are aware that the granularity, the level of granularity determines two things, either the exclusion or a very high pricing of the cost of insurance, also basic essential insurance. So you see that all this, of course, is as an impact. Then maybe it's about the health data space, yes, but and here you see that since in some cases it's even mandatory, and it's important data also about, for example, very sensitive pregnancy or not, the discussion has to be also in this case a societal discussion, and the European health data spaces, however, in Article 35, tries to steer the discussion, saying, but please, these kind of uses of the data space, these are not allowed, these are prohibited, because are uses that at societal level cannot be envisaged. We tried as a DPS, DPB, also in the opinion on the Data Act, to exclude wellness app and the use of wellness app, connected devices for basically